Hey Estie, welcome to Spa Boss Talks, the go-to podcast for estheticians ready to elevate their game in the world of beauty and business. I'm your host, Nicole Lancaster, a six-figure solo esthetician and former spa manager with a passion for helping you turn your aesthetic skills into a thriving business. Whether you're just starting your journey in the beauty industry or you're a seasoned pro looking to take your spa business to the next level, you're in the right place. I've walked the path from the treatment room to managing a 6 to 7 figure spa, and now I'm here to share the lessons, challenges, and triumphs with you. Together, we'll dive deep into the business side of aesthetics, from mastering marketing techniques to building lasting client relationships and everything in between. So get ready for candid conversations, expert interviews, and actionable advice that you can implement right away. Spa Boss Talks is not just a podcast, it's your go-to resource for becoming the spa boss you were meant to be. So whether you're tuning in during your commute, while treating clients, or winding down at the end of the day, get ready to be inspired, informed, and empowered, because this is Spa Boss Talks, and I'm Nicole Lancaster, your guide to success in the world of aesthetics and business. Welcome back to another episode of Spa Boss Talks. I am so excited for my next guest, Shaunette Stokes. She's the founder and managing partner of Stokes Law Group. She's a successful entrepreneur and attorney with a passion for empowering business owners and helping them achieve their goals. With years of experience in both the legal and business realms, Shaunette possesses a unique perspective and skill set that enables her to provide invaluable guidance to her clients. She's a graduate of both Florida A&M University and North Carolina Central University School of Law. Her legal practices range from intellectual property, estate planning, probate, and personal injury. She is a practicing lawyer right here in the state of Florida, and she's dedicated to staying at the forefront of her legal knowledge. She is a brilliant woman, and I am so excited to have her on this episode. Here's our conversation.
Well, welcome back to another episode of Spa Boss Talks. I am so excited to have Shaunette Stokes on here with me today. Shaunette is my trademark and business lawyer. I have talked to a lot of you about her. I'm always singing her praises. But she is here to discuss a common phrase in our industry that has recently been trademarked, Estie Bestie. And a lot of us are really confused. A lot of us have been using that term for a long time. So we are going to get some answers from Shaunette today. So Shaunette, thank you so much for being here. If you don't mind, can you just tell our listeners a little bit about yourself and how you got into trademark and copyright law?
Well, first, thank you for having me. I have been practicing trademark law since 2014, so it's been close to 10 years that I've been doing specifically trademarks. And, I got into trademarks specifically because I like to see brands grow and I want to make sure that they're protected as they grow. And I actually got into the clinics in law school. So my law school offers a trademark clinic where we actually get clients from the community and we are filing trademarks on their behalf. And I just fell in love with the idea of at the, grassroots phase of a business, I'm helping get it protected. And I love that. I love to see clients happy after that experience.
Yeah, now you have helped a lot of entrepreneurs. I feel like your specialty really is entrepreneurs, like you said, helping people get started. A lot of us don't actually know, though, what a trademark is, what is copywriting. We hear it and we just think that's an expensive service and we write it off like we don't need it, but it's very important for brands to know and to have. So can you explain a little bit about what a trademark and what a copywriting or what it is to copyright your materials?
Absolutely. So the difference between trademarks and copyrights is trademarks is for your brand identity. So that would be your brand name, your slogan, any colors that are associated with your brand. So the Tiffany blue, that color is protected. Then the red bottoms on the Louboutin shoe, that is also protected. And with copyright, that's content. So think about it, with entrepreneurs now, we have to be content creators. So that is your
Yeah.
blog post, your, any skits that you've created, you want to copyright those and make sure that if it's being reproduced, someone has to come to you to reproduce that information or the content that you've put out. And there is a slight overlap with trademarks and copyrights. I always tell my clients that have logos, you want to make sure that you not only protect your logo under trademark law, but you protect it under copyright law. But a caveat with that is a lot of us are not artists. So we're not going and creating our own logos. So when you have a contract with your graphic designer, you want to make sure that there is a release. So they're releasing ownership of that logo to you. And if you don't have a release, I would strongly suggest that you contact your graphic design company and have them send you over a release, because generally that is customary practice after you've finalized your bill with them. So when you register the copyright, you'll let the Copyright Office know that either the copyright was assigned to you, so full ownership was assigned, or they released all ownership to you, and that would be via contract. So the assignment and release would be probably at the end of your graphic design experience with that company.
Now, what happens if you design your own logo in something like Canva? Is that something that you can then copyright, or is that not necessarily, because it's pretty much a file that anyone can use, or
So
design
you
anyone
have
can
to
use?
check the terms of use with Canva. And
Mm.
Canva, I believe, I have not looked at their terms of use recently, but I'm hearing that they're still maintaining ownership of the brand or the creative works that is within the software. So I would be very cautious with that.
That's good to know. And in our industry, I have seen a lot of people and a lot of estheticians and beauty pros post about this, where they work for someone and they create menus or they create content, business cards, or they're even just working with someone, or someone just goes online and steals their designs, steals all their packages, steals their menu designs, steals their logo and their branding. Is that something that someone can trademark as well to keep themselves safe?
So a lot of the theft that comes into play when it comes to employees coming to work with you, there's two things. Well, your brand is, of course, the identity. You can trademark the brand name, the slogans, the logos. There's trade secrets that is also a part of intellectual property. And your trade secrets are things that you want to maintain as a secret. So if you have a sous chef that comes in and they have access to your recipes, you want to, before you give them access to your recipes and the know-how of your business, the internal workings of your business, you want to make sure you bind them in a confidentiality agreement and a non-compete, and just make sure that the parameters are in compliance with your jurisdiction. What I mean by that, Florida has specific requirements for non-competes and non-disclosures, and any other state may have different requirements. Another part of having them come in and work with you and creating content, that is also a work for hire agreement. So I would recommend that anyone that has, and that's generally a part of a non-compete and a confidentiality clause, that you include work for hire language in there that says, hey, anything that you create within my business is owned by the business. So
Mm.
that they know, all parties know, that any intellectual property that is created is owned by the company.
I think that's something that's missing in our industry too, is just the specifics, protecting yourself legally in your business. I've been in this industry for a very long time and a licensed esthetician working for spas for 12 years. So I've learned to be on the offense.
Mm-hmm.
So constantly in groups, people are saying, I've reached out to you about non-competes before,
Yeah.
constantly in the groups, people are saying, oh, non-competes don't hold up. But I've learned from you, they actually do. If it's
Mm-hmm.
not the whole, then it's the part. So I just don't think in our industry, we're properly educated on the legalities, even like you're saying, the NDAs and the non-competes. You may not think that it's important, but I think it's important to be on the offense and to have someone like yourself where you can even just shoot a question to or ask or have the law. I mean, you've done a lot of legal papers for me. So even
Mm-hmm.
something like that, just to keep yourself protected, you don't have to
Absolutely.
necessarily enforce it, but to have it in case it turns really bad is something I think is really smart to do in our industry. Um,
And the
let's move on
offense
to,
is the operative word, though. A lot of
yeah,
people are always on the defense, and
yeah,
they generally get an attorney when something happens. And it's
right.
sometimes too late, because you can't unring a bell. When someone steals your intellectual property, what do you do with that? Now you
Yeah.
have to sue, so you have to put things in place that prevents that, and that lets all parties know who owns that IP and who doesn't own that IP. And contracts are the best way to go.
Yeah, I think I learned that actually going through custody of my daughter. I was served papers
Mhm.
and I was caught off guard and I was like, oh my God, now what? And
Mhm.
you're right, it's so much more stressful to then
Yep.
try to go through this long legal process of getting what's yours, or I mean, that was my kid. I share custody, but it's such a long legal process to have to try to correct something that you
Yeah.
could have just easily done and cost you way less time and money if they would have just gotten a lawyer, reached out to you first, um, protected their intellectual property. Now let's talk about
Absolutely.
the hot topic of
Okay.
Estie Bestie. A
Okay.
lot of estheticians are all we're confused, we're up in arms. I mean, it's a very common term that we have used for years and years and years. We have signed off, saying that word, or that term. We have greeted each other that way. We've used it with our clients. Um, how can a term that is so commonly used and it's been so widely used for such a long period of time be trademarked?
So you have to ask yourself, in what context are these other estheticians using it? Right. So if they're just using it in conversation and not associating it with their brand identity, then it's not protectable. Right. But once
Mm,
it becomes a part of your brand identity, so say for instance, it's your slogan, and
yeah.
everyone begins to know you as the SD Bestie, then you can protect others from utilizing that brand name. Oftentimes, when you have a generally used word, you have to, if this is a word that you want to protect, you have to be very proactive and protect it.
Mm,
But the caveat is, if someone has used it in conjunction with their brand as a slogan and you filed it before them, they can come in afterwards and file suit against you for trademark infringement. Because again, if you were not the first to use that mark, you are subject to a lawsuit. So you have to be mindful of, while we do have the rights to certain trademarks, if you did not have that, if you did not use it first, then you could potentially be sued in federal court for trademark infringement. So I would be very mindful of who used it first and how it was used. And also, if you are a trademark holder, you have the responsibility to police that mark. So once you have the federal rights and the exclusive rights to use that brand name, you can stop others from using it, and you should stop others from using it. Otherwise, it will become generic. And a good
yeah.
example of a generic mark is Velcro. Have you heard of, everyone calls Velcro, that,
Yeah.
you know,
It's
so
Velcro.
yeah, it's Velcro, but it's not necessarily from the company. So when you see
Right.
the latch, and I think it's called latch and hook, the actual technical term of it is different from Velcro, but we have called it Velcro. And Velcro, the company, has spent a lot of money to make sure that their consumers know that that other stuff that you see out in the market is not Velcro. And you have to be very cognizant of making sure that other people do not genericize your brand. Another company is Google. We always say Google it, but we're not necessarily
Yeah.
using Google. We could be using Yahoo, we could be using Bing. You have to make sure, as the trademark holder, that no other brand or any consumer is using a phrase in conjunction with your brand name in a generic manner. So that is something that, unfortunately, as a trademark holder, if a brand is constantly being used by others, you're going to have an uphill battle with protecting it and stopping users from using that brand.
So I just wanted to have clarity because you said if somebody's using it before the person files trademark. So if
Mhm.
somebody has used that term, Estie Bestie, in their business for 15 years, but has
Mhm.
never filed a trademark,
Mhm.
and then somebody goes in and has been using it for 10 years and files a trademark and gets the trademark. Could the person of 15 years then go in and sue them and say, wait a minute, you can't trademark this because I've been using it longer than you?
So when you added the timeline, that makes it a little bit more complex because after 5
Okay.
years, you get additional rights. So
Okay.
after 5 years, your mark becomes incontestable, meaning that if you were sued, you've already done the work with the trademark office, having protected it. And
Mhm.
now, if someone sues you for infringement, you don't have to show the court that you had priority because
Mm.
you've stood within the USPTO as a registered trademark without any other parties claiming ownership. And now all of a sudden, what, 5, 10 years later, they want to come in just because you've registered it.
Yeah.
A lot of things could come into play. One, your mark is incontestable. Then also the statute of limitations. How long did you allow for this other person to use your mark without you coming into the court and saying, hey, this person is using and infringing on my register or on my brand? You can't just sit on these things. You have to act right away. So
So if
adding timelines, 15, 10 years is going to make it very difficult to.
so if it's within those first 5 years of somebody registering a trademark, the
Mhm.
person using that brand name before can contest their trademark, or is the trademark just set in stone, solid? I've got the trademark now; it's mine.
So if they are a new user of that mark and they've gotten the registration, and next thing you know, someone who had the brand name 6 to 10 years before them, and then all of a sudden you started using it within the last year or two, and you've gotten it registered, then yes, absolutely. That superior owner, the person that used it first, can very much so come in and file suit against you. They can do two things. If your trademark is pending before the USPTO, they can come in and object to your registration at the publication phase, which is the final phase of the trademark registration process. Or if you've gotten your trademark, someone can come in and file suit in federal court against you for trademark infringement because you
Right.
had common law rights. But you have to make sure if you have common law rights that that person is in that same area. So you both have to be in the same state in order for your rights to trump theirs. Because common law, of course, is specific to that state, but federal is across the United States. And if that person has a registration that covers the entire United States, you have to come into federal court to get their registration invalidated.
Can you just explain what the difference is? Because people think, and I explain this in some of my classes because I've learned so much from you. But people think just because they register their name, their LLC with their state, then
Right.
people can't have that name. They don't understand that that's not protected. That you can have a million different variations in your state. So can you just differentiate real quick, like the difference between registering your business name and actually getting your trademark registered with that business name?
Absolutely. So, with specifically for the state of Florida, when you are filing for a business, you can make the word plural or you can add additional terms. And the state does not do a full and thorough search on brand names. As long as the phrase isn't exact, then you're good to go. But
Yeah.
you're subject to infringing on someone else's intellectual property rights because the federal trademark laws say that if it sounds like that mark or if it looks like it in any way, you are infringing on that person's mark. So it doesn't necessarily have to be spelled the same or even look alike. But if it sounds alike, then you are in hot water. So my recommendation is when you're thinking about a brand name, contact a trademark attorney before you even file for the registration with the state, because you're going to have to, and I've had clients do this constantly. They come to me having already registered their LLC, and then I tell them, well, hey, unfortunately, this name is taken in the USPTO's database, But of course, in Florida, no one's using it because Florida's not going to check California. They're not going to check New York's database, and they're not going to cross-reference any other states' databases and compare your mark to other people's marks. They're not going to do that. So you have to do the work, and you have to make sure that your brand is protectable and that you're the first user of that mark. Otherwise, you're going to have to spend a lot more money having to go in and change your paperwork. And it's very tedious. You have to change the name, tell the IRS that you've changed the name, contact your bank and let them know. It is a long and tedious process. And you could have avoided all of that by clearing the name with a trademark attorney first.
And I think that would probably be worst case scenario, that you have built this beautiful brand for 10 years, thinking, that you're in the clear, even 5 years, even 3 years, you're building this brand, building your clients, you're recognizable by your name and your branding. And all of a sudden, you get served papers because you're infringing on someone's trademark. Just like you taught me, I have V-line women, but my category is intimate skincare. There's a million V-lines. I think there's like not architect, like shipping. I think there's manufacturing, like there's a bunch of different companies named it, but when it comes to trademark, it's not in the same category as me, so it doesn't cause confusion among consumers. And I know that you do a lot of research, because I remember even helping like with social media, because I'm Sherlock Holmes and I just love to do that. So we were, you had someone
On
that had the mark, but
Instagram.
it was coming up for,
Yeah.
expiration. And I'm like, oh my God, she hasn't used it in this long. Look here,
Yeah.
we were like deep diving in social, but it goes so much deeper than that.
Mhm.
And people think they can just do some research on their own in the USPTO and it's not trademarked, so they're good. But I feel like there's so much more research than somebody just trying to do it on their own and hop onto like USPTO and thinking that that's enough.
So a lot of people think that they can just go to the trademarks office and do a quick search. Let me tell you, their website is not like Google. It is not user friendly. There is a lot of technical ways to search to yield the best results, and trademark
Mhm.
attorneys are trained for that. If you don't have a trademark attorney that's trained to actually search the USPTO's website, then you probably need to find someone else, because you want to make sure that that person knows how to go straight to the source, which is the trademark office's website. Now, there are third-party companies that a lot of trademark attorneys use, to streamline the research, but at the bare minimum, they should be able to know the trademarks database and how to search it.
I remember when we filed mine, someone had filed 1 month before.
Yeah.
And the way that the lawyer had filed it too, it was just weird. You're like, this is just like something's off. So I don't think that trademark is really something that every lawyer can do. I feel like you said there has to be that specialty and knowledge and education to make sure their clients, are protected.
Another thing,
Um,
people have to realize that timing is also a critical thing, because
yeah.
as you said, someone filed 1 month prior to you register or filing for your trademark. And oftentimes people come to me and say, okay, Shaunette, let's clear this mark, make sure that we're able to use it. And then, they want to save money for the service and then finally file. A lot of those things happen very frequently, more often than not, where there's a gap in time where we do the research and then you turn around and file the trademark application, and you find out, of course, prior to filing, we find out, okay, there's someone that's already pending, but they filed in that time frame that we were waiting for. And so I tell my clients that time is of the essence. It's very critical to get your trademark application in, and you want to make it's just like going to the DMV. You have to put your number in first. You got to make sure that you're the first to be called. And if
Yeah.
you know that that brand name is what you're going to settle on, then you should very much so prioritize filing it right away, especially once you've gotten it cleared. So as soon
Yeah.
as you've gotten a clearance from that trademark attorney, file it right away.
Mine was such a pain in the ass because of that. And you couldn't even see in the beginning that it was filed because it was so fresh. So when we
Yeah.
filed, we thought we were in the clear. We're like, yes, it's mine.
Hmm.
And then all of a sudden we're like, uh-oh, somebody filed,
Yep.
1 month. And we fought it for 3 years until finally they
Yes.
weren't interested in anymore. The I think it was a doctor, and she like let go of her skincare business, and we
Yeah.
were finally able to get it. But it was such a pain to then
Yeah.
try to fight for the mark that I wanted over a course of 3 years when it could have just been, easily avoidable if I had done it 1 month
And
sooner.
this was during COVID. So we were like, is she still alive? Like we were worried at one point.
I kept saying COVID got her, and I'm like, wait, I hope
Yeah.
it didn't get her. It just got like her
Right.
skincare business.
Yeah. Like,
I hope
hope
it just
she's
goes with
okay.
business.
But,
Yeah.
just maybe she's pivoting to a different project.
Yeah. Yeah. When the website was down, I was like, yay, but
Yeah.
also uh-oh. So
Right.
so coming back to the Estie Bestie
Mhm.
trademark, are there rights that the community has to use it? And how can we use it? Is it something we can use, and how can we? Or is it something we should just 1,000,000% steer clear of to keep ourselves and our businesses safe?
I would, especially knowing that there is a registered trademark. See, we can have this conversation because this is dialogue and educating the community about, trademarks and using that as a subject area of discussion. But when it comes to utilizing the brand and in conjunction with your services, then you are most certainly infringing on that person's trademark. So I would recommend that anyone that has knowledge that this person has trademarked her brand should stop using it in conjunction with their services. Now, if you're having a conversation with your friends and say, "Hey, Estie Bestie," that is perfectly fine. But if you're posting it and putting it on your website, then you are going to be in hot water because she could come in and say, hey, this person is capitalizing on my brand name in conjunction with their services. So I would just steer clear from that.
So if I'm posting something to other estheticians and I say, "Hey, Estie Besties," I'm infringing.
Yes. Yes.
And
So just be
if
mindful of that.
it's so hard because we're so used to it. Or
I
even like
know.
when, we sign off because we're talking to our clients or on social media, or it's like,
Mhm.
"Hey, your Estie Bestie here." But I mean, that's clearly infringing because she's, trademarked. And I think that was kind of her perspective too, is that nobody had trademarked it yet. The social
Mhm.
media handle was there, so she could get it.
Right.
It's just such a common used term that a lot of us were like, wait, how could that be trademarked? But she did, and she got it,
Yeah,
you
and as
know?
long as she is policing it the proper way, making sure that no one is using it in conjunction with their brand, then she's going to have exclusive rights to that. Until someone comes in and says, "Hey, I was the first user of this mark," there's nothing that will stop her unless she gets sued.
Yeah, so I think that's where people are kind of fearful and like really upset too, is that, she is enforcing her trademark.
Mhm.
And so people that don't even know that trademark exists have built these platforms with that in their business name, or they've built these platforms using that. And now they're getting messages to shut it down, to change their business.
Mhm.
So what can she enforce? Like if she sees on social media somebody has like, Nicole's Estie Bestie Spa, like how can she enforce that, and what type of legal actions can she take against someone?
So she can first send a cease and desist letter to anyone that's using that mark in conjunction with their brand or their business or services. And
Mhm.
if they don't comply, then she could file suit. I always tell clients that when you're sending out a cease and desist letter, you need to be ready for a lawsuit because if you're just sending out a letter and have no intention on filing suit when that person does not stop, it's just like going to rob a grocery store with a water gun. What are you gonna do with that, right?
Right,
You're
right.
giving idle threats, you are
Yeah.
well within your right to put someone on notice of infringing on your mark, but if you don't do anything about it, then you might as well have not sent the letter. Because there's a lot of people that will send out cease and desist letters, and then when the person ignores them, they don't do nothing at all. They're like, "Okay, well, they didn't see my letter or they didn't comply, then I don't have the funds to even file a lawsuit." Then you need to find another route, meaning at least I would say if that person is using it on social media, for instance, what you can do is contact Instagram and Facebook and send them your registration certificate and let them know that this party is infringing on your mark, they will then shut down that page. And I hope I'm not giving her any ideas.
No, I think she already has the idea because from what, I've seen online.
Like, it's going to be a lot of pages shut down. But that is
They're going to
something
get
that they can
messages,
do for
Shaunette.
free. Right. Like, sorry, I didn't mean for that to happen. But she can certainly get pages shut down that have wrapped their brand identity under the Estie Bestie moniker. So just be mindful of that. But I would also file suit if I were her. But you have to have the funds to do that.
Yeah, and I mean, filing suit, the minimum is what, $500 for a civil suit
Well,
without
that's
a
the
lawyer fee?
filing
Like, I
fee.
mean,
Yeah, and
yeah.
that's federal. So you would want to file if you had, well, especially if they have a federal trademark, you would want to file suit in federal court.
So if
So
she went for everyone, it'd be a few $100,000 to try to sue
yeah,
everyone.
yeah,
Yeah,
absolutely.
that's a lot.
And so I tell my clients that when you have a commonly used phrase, it's
Hmm.
beautiful to have that trademark registration, but you have to think about how many people is using that phrase, right?
Yeah.
Because if you're going to stop everyone from using it, it's going to be very expensive to do that.
Mm.
You have to ask yourself, how much money do I have and how many resources do I have to stop them from using that? If you don't have that, then I would recommend choosing a different brand name.
It seems like a long, hard fight
Oh, it
for a
is.
brand name. I mean, I'm kind of in the middle as somebody who holds a trademark. I totally understand it, but as an esthetician who's used that phrase for, 12 years now, it's kind of like, ugh, like
Mhm.
because I mean, I've used it a million times and now I can't, or now, it's always just something fun we said too, to each other, to our
Yeah.
clients. Um, so I definitely understand her perspective, but I also understand the other perspective as well. So if she decides to go after someone, or if she decides to ask someone to take it down, what's take down like social or take down any videos, is there something that they can do to resolve um, resolve the conflict without having to go? Like, what should somebody do to try to resolve the conflict with her if they don't necessarily want to take it down, or she's probably just going to tell them, take it down, if you don't, it's at your own risk?
You can try to have a conversation with her. If she's receptive of that, um, more often than not, when someone has a trademark, they know their rights. They know they have exclusive rights, and they're
Yeah.
very firm on policing those rights. So I highly doubt that she would be receptive of anyone maintaining use of that term, because a defense in trademark infringement is acquiescence. So essentially, if you and I have had a conversation about me having knowledge that you're infringing on my mark and I continue to allow you to use it, and then say 2 years later, I decide, okay, I'm tired of Nicole using that mark, I want to file suit, and you have evidence of us having that conversation and me being okay, then I have nothing to fight for because I've
Yeah.
already acquiesced to your use of the mark. So you just have to be very mindful of, when you're having conversations, documenting those conversations, especially having those conversations in writing. And if that person allows you to continue use, maintain proof of that. So
Yeah.
that when they, turn around 2 years later and say, I don't want them using it anymore, you have documented proof that they've allowed you to use it. It's kind of like a license, right? They've allowed you to use the mark, I mean, without compensation. And she has the right to allow others to use that mark with some kind of compensation. So you could have a non-exclusive license. She could sell the use of that phrase if she so chooses. But again, that opens the door for having to police who she's given permission to and who she hasn't, and then
Yeah.
putting those people on notice that she hasn't given permission to, that they are infringing on her mark. So I just be
That was
mindful
going to
of
be
that.
my next question, would you suggest if, she comes to someone, would you suggest them offering that, like saying, hey, I've been using this branding for a really long time. Is there a licensing agreement we can work out so that I can still use it? I'm in a totally different state, we do different services. Like, would you suggest somebody asking about licensing or just kind
Yeah,
of
I would.
sharing it? I don't know.
So it would more so be under it would be a coexistence agreement more so than anything, right? And that is with compensation. So the coexistence agreement is the license to use my mark while I'm using it. So sometimes
Okay.
people will have a license and I'm no longer using it, but I'm allowing you to use it.
Mhm.
So in this instance, the coexistence agreement would be I'm allowing you the license to use this mark while I'm using it. And you have to ask yourself, what benefit does it have for her to allow other people to use it while she's using it, right? If she has no benefit other than monetary gain,
Yeah.
then it probably won't be fruitful for her because it's going to be a lot more time consuming to police it than anything else.
I mean, that could be a little side hustle, right? She
Yeah.
wasn't planning on growing her brand to something huge. That could be a little side hustle, just selling agreements to her
Yeah.
licensing or to her trademark. Are there steps that we can take as spa owners, as estheticians who own our own suites and entrepreneurs? Are there steps that we can take to avoid getting into a mess like this? And what should we do if we have commonly used phrases or we're using something that's a pretty common term in our branding? Are there steps that we can avoid to not end up in some sort of mess with a commonly used phrase like this?
So I would first contact a trademark attorney. I sound like a broken record. I'm sorry. I would contact a trademark attorney to clear, every element of your brand. And even though you know that that phrase is commonly used, if it is a part of your brand identity and you've adopted it as such, then I would protect it. But that goes back to the original conversation. If you know that there's third parties that have used it before you, then it's going to be very hard to maintain that protection. Because another thing with trademarks, you can sue. So if that person is suing you, so if I'm suing you for trademark infringement, right? For using, say I'm the Estie Bestie trademark holder, and I
Yeah.
see that you've used Estie Bestie with your services and I file suit, I can counter sue you, or sorry, you can counter sue me for fraud upon the USPTO, essentially saying that Shaunette or Nicole knew that Estie Bestie is being used by other people. So when you filed the trademark application, the trademark office asks you if there's anyone that you know that has priority rights to this trademark. If you knew that at the time of filing, then you could very well get your trademark canceled for the USPTO because of fraud, because you had knowledge that someone existed and you decided to check that box and say, no, I had no knowledge that someone had this mark. And now, when you're in the middle of a federal trademark case, you have to explain to the judge why you checked that box.
You are so full of tea today. Like,
I'm sorry.
you are so full of tea. I love it so much because this is what people, again, we don't understand. So
Mm-hmm.
having these little insiders to not only as a trademark owner to protect themselves, but again, it's so commonly used. And if somebody has built a business off of this for 10, 15, 20 years, and now they're having to shut it down, it's important for them to know their rights as well. So I didn't
Absolutely.
even know that that's something you could do. So that's amazing.
Yes, but we have to remember that lawsuits cost a lot of money
Right.
and they are very much so emotionally they're time consuming and they
Yeah.
will take a lot of your emotions because there's parts of lawsuits that are just not fun. You know that you have all of the evidence that any court will sway in your favor, but it's a matter of getting to the finish line. And it can take a lot of painful experiences throughout the entire process, and it will honestly make you want to give up. So just be mindful of that. Lawsuits are not fun and they're expensive.
Even in our process with it taking 3 years, there were times where you're like, Nicole, what are we doing? Are we going to keep on? Are we going to stop? Are we going to, are they bluffing? And we call it. And I'm like, Shaunette, it's already been 2 years. Like, what's another
Yeah, let's
year?
fight.
At that
Yeah.
point. Yeah. At
Yeah.
that point, I was like, we're already in, like, let's just do it. And
Mhm.
I'm glad that we did because we ended up getting
Yeah.
it. But yeah, legalities, you think like, oh, I'm going to file a suit, and you think you're going to go to
Mhm.
court tomorrow, and you're
Mhm.
not. Like, you get on the
No.
docket, months later, 90 days, like, it's a long time. Legal processes are long, tedious
Very
things, and they're
long.
not fun at all.
Not at all.
So, beginner advice for somebody who has just opened their spa and wants to trademark, what would you're going to say it? I know the answer. What would their very first step be to protecting their brands and wanting to trademark?
Of course, contact a trademark attorney and
Shaunette
clear the
Stokes.
name. Right. Clear the name. Make sure that name is, not taken. And I would also pay that attorney at that moment, because you could
Yeah.
even file an intent to use application. So you don't
Mm,
necessarily have to be in commerce, you selling your services at that very moment. You can
yeah.
file an intent to use application, and by the time that trademark application gets assigned to an examiner, you have already launched, and now you can tell the USPTO, hey, I've launched my trademark and my brand, and I'm using it, and letting them know that how you're using it, showing them websites, uh, business cards, everything that you need to show proof of use. And I would also tell them to make sure that they have all of the contracts in place beforehand, because a lot of us, we start off, with grassroots. It's just us. We are the marketing
Yeah.
department, we're the accountant department. Like, we hold several hats, but
Yeah.
inevitably you will be, hiring additional staff and bringing other members to your team, and you want to make sure that you have contracts in place before it gets there, because when that time comes, you want to have them ready to go and protect all of the things that you've created. When we are in business, we don't realize how many steps and how many processes we've developed within our business, and
Yeah.
it's made our life much easier. But it is also intellectual property, because you could for sure sell those processes to a third party, but you want to make sure that your staff protects that intellectual property, because that is considered trade secrets. And the only way
Yeah.
that you can protect a trade secret is by maintaining its secret under contract law. So I always tell people, have the right contracts in place and protect your trademark with trademark registration.
Yeah, whenever because we make products in the spa, and anytime I've hired people or people have, come even into the lab, you created an NDA for me because we want to protect that. We don't want people going and saying, oh, this is how she does it, or, this is what I've learned, or this is the formulation or ingredients. Like you said, you really want to protect your brand. And it's something that I don't think people think about. I have a few friends who are looking to start a business with other people. And again, I learned this from you. You're making me legal savvy. But they say, oh, I'm going to go into business with this person. I'm like, oh, do you need a operating agreement? And they're like, well, what's that? I'm like, oh
Yeah.
no. I'm like,
Yeah.
Shaunette Stokes, here's her number.
Yeah.
Because
They
people
don't
don't know. They're like, oh, I
know.
got a business partner. Now we're going into business together. But
Yeah.
even just reading the operating agreement that you created for me, there's so much little intricacies, even just something you wouldn't think about like your partner taking out a credit card or debt
Yep.
against your business, or,
Yep.
who owns what portion of it and who can make decisions regarding financials about your business. Like all
Mm-hmm.
those little things you don't think about, you're just like, well, I got this person, it's going to be great. I got a partner to help take some of the stress. But unless you have a legal operating agreement, like we said earlier, it can get real bad real quick if you're not on the offense.
Yeah, I've seen businesses that go in, people go into business with friends, and it's essentially a handshake deal, because they just have
Yeah,
faith that that friend won't do them any wrong. And
right.
what happens when things go left? Also, you have to ask, well, what happens if a member in the business passes away? Are we going
Yeah,
to give their interest to their family, or do we assume their share? And is their estate entitled to that portion? You don't want the state's law to dictate how you manage your business. You get to dictate that, but the only way that you do that is through an operating agreement. If you have an LLC, if you have a a corporation, be it a for-profit or a nonprofit, those are your bylaws. And then if you have a
Yeah.
for-profit corporation and you have shareholders, then you have shareholders agreement. So you want to make sure that you have all of the proper paperwork in place, because everyone that is involved needs to know their rights. And you don't want there to be a time where they have to go and file suit just so that a judge can tell all parties their rights, because that generally is the primary reason why, lawsuits happen amongst members. Different partners have a different assumption of their rights and obligations, and they're all on different pages, and it takes a court to decide the resolution of that issue. And you don't want that. You don't know what that judge is going to say, you know?
Yeah. Well, God forbid you have a partner and now they've opened up a credit card against your business and racks up to $100,000, and you have no idea until they start calling or mailing. You just don't know. So having that in, I'm such a Virgo in this aspect, and again, I'm on the offense now. We're black and white, like, no, this is what it says.
Yep.
I even go to
Yep.
my time sharing sometimes. I'm like, wait, is that my weekend? Okay, it's not, like,
Yeah.
but
Right.
I need it in writing, because I've learned
Hmm.
just being in the industry over the years, you can get burned so quickly by
Yes.
so many people. But if you have yourself protected, you have created NDAs for me. I
Hmm.
think it's even a really great idea to have a operating agreement between you and your 1099s, just so they know what to expect from you as well. What they know, the trial is, what their compensation is going to be. Um, I think that's a really great idea too. And then the non-competes, which is big in our industry, and everyone's lawyer. We're always throwing out legal advice. I always put in there, like, my attorney told me, like, my
Yeah.
attorney said, like, this can't hold up, because we all are just telling each other, oh, it's not going to work. It's not going to hold
Yeah.
up. But that's not true. I mean, you've seen non-competes in our industry for the entire state of Florida, and you were like, actually, this could hold up because the court thought she was of sound mind when she signed it.
Yeah.
So even protecting your business with non-competes, I mean, you would say is a very important thing as well, right?
Yeah. So with non-competes, you want to make sure that the restrictive terms aren't limited through the entire state of Florida, unless it is a service that can extend beyond. So for instance, if
Mm,
you have an esthetician and that person is only limited for their area, so they can come in and go to St. Pete, Clearwater, but you don't want them in Brandon, Ruskin area. You want to make sure that the mileage is not too restrictive, because that portion of the non-compete can be canceled out. So she
okay.
or he could go to court and say, oh, okay, this is too restrictive, right?
Yeah.
But certain types of practice areas, or for instance, if you have someone that can work electronically, so if that person has a school, an academy, an online academy, you could say,
Yeah.
well, you can have an online academy, but you cannot try to get Florida students, but you can get students from other parts of the United States. That may very well hold up in court, because it is restricted to a specific geographic area that
Yeah.
you once serviced. So you want to just be mindful that the non-compete is not too restrictive. And I always just put at least, 20 to 40 miles
I
with
mean,
me.
yeah, that's even still, a pretty big, but it's, again, like you said, it's something that you don't necessarily want to have to go to court about. So I tell people too, if they're looking to sign their lease, just be mindful of their non-compete, because it may hold up, it may not, but it's such a pain in the ass to figure out if it does.
Absolutely. It costs.
Had
Everything costs.
Yeah.
Going to court and having a judge decide whether or not that contract it can be upheld, that costs. So, and it costs time and money. So you just have to be mindful. Is it worth it?
Well, like you said too, you never know your judge. Like when it came to my custody, that was the first, like, few months the judge had been in family court. I'm like, this isn't criminal defense, sir. Like that, we're talking about my daughter. You're just up here
Yeah.
throwing around rights, so you
Yeah.
never actually know how much your judge necessarily knows, um, about business or about, your instance or your situation, because you never really know their background either. So it's in the state. I mean, we know from paying just taxes and fees and licensing, like the state loves
Mhm.
them some money. So if you start having to go,
Absolutely.
like you said, with
Absolutely.
filing fees, and they're going to
Mhm.
get their money some way, somehow. So,
Yeah. And one thing with judges, especially in Hillsborough County, they rotate the judges. So you'll have a
um,
previous foreclosure judge now in family law, or a criminal law judge in family law. So yeah, it happens
they
often.
just
And
throw out those rights.
yeah, and they don't know what's happening. They're just
Yeah.
supposed to be the neutral party, but then they sometimes throw out their own opinions and they rule in a way that is based on their own beliefs. And you have to be mindful of that as well.
Yeah. Yeah, I mean, that's it. Mine was like,
Yeah, it
very
happens.
liberal in what he was doing.
Uh-huh.
He's very much Oprah with his rights.
Yeah.
Um,
Yep.
I was like, oh, this is why they have their own exit door. I get it now.
Yeah.
I understand.
Yes.
I was waiting to like stare him down. And I was like, oh, he's not coming. He goes out the
And that's
back.
why they have a bailiff.
The glares I was gonna give
Yeah.
him. I was like, I'm gonna show him. No, I'm not. He
Right,
left
you
and went in
can't.
his Porsche and got away. So are there any final thoughts or any final advice that you can maybe give our listeners in regards to trademarking, whether it's their own business or just keeping themselves and their businesses, safe from phrases and terms like Estie Betsy that are already trademarked, and in order to keep themselves open? Is there any final advice that you would like to give our listeners today?
Absolutely. I think that everyone that's listening should know that they should prioritize uh, everything legal in their business. We tend to have funds set aside for marketing, right? But we never have funds set aside for law related things for our business, like getting contracts drafted and getting our brand protected. Another thing that
Yeah.
I would also recommend is that people think that getting a trademark is a one-off thing. As you are developing and expanding your brand and your services, you should always be thinking about other ways to protect it. So, what other parts of your brand identity can be protected? Should I now focus
Mm.
on protecting my logo since my brand name is protected? Should I protect my slogan? You shouldn't just think that now that I have one trademark that I'm done. No, you should be building your trademark portfolio, because it's just like Monopoly. If someone wants to use that brand, they have to pay you, right? And it's a
Yeah.
lot of money in intellectual property, but you have to have the exclusive rights of ownership before you can even sell those rights. So just be mindful. Once you prioritize your legal rights, it will be very fruitful in the end for you.
That's great advice. That's good advice. And like I said, I don't think that enough of us actually take that into mind
Yeah.
until we have to be on the defense and we need you. And
Mhm.
we're like, oh, does anyone have a lawyer? It's like,
Yeah.
well, that's just
Right.
our actually. So we have a program that we launch twice a year, and it teaches estheticians how to start their business from the ground up. And the very
Mhm.
second module, we teach people how to register their LLC. And
I
then you
love
were
it.
so gracious and did a talk with us last
Mhm.
year about
Mhm.
trademarks. And you're actually the resource in our second module. They get your contact
Oh,
information. They see the
awesome.
call with you, because I think it's so important to start off before everything else. Get your
Mhm.
business plan, get your name, and talk about trademarking and registration. Because, like you said, even if you aren't using that mark yet, but if you have the idea, and the person who filed before me, that's what they had the intent to use. So if you
Mhm.
intend on using the trademark, intend on using that name, narrow it down and reach out to you and get it filed. That way it's protected, and build from there. But, don't build and then try
Absolutely.
to protect.
Yeah.
Do like you say.
Yeah. Because if you try to build, if you build and then try to protect, then the foundation will crumble because it's going to be
Yeah.
difficult to do it
Yeah.
on shaky ground. So I agree with you for sure.
Yeah. Well, Shaunette, thank you so much for being here today. How can
Thank
people get a
you.
hold of you if they're interested in your services? How can they find you on social? What's the best way?
So you can find me on Instagram and Facebook and all platforms at Stokes Law Group, Stokes Law Group. Or you can go to my website, www.stokeslegalcounsel.com, and counsel is spelled COUNSEL.com. And you can also call my office, 813-444-4156.
I have referred people to you. I always do.
Thank
and
you so much.
nothing but your praises, because you are
I
just
appreciate you.
such an intelligent woman. Not the fact that you're a woman and we're a little feminist on this side, but you were just such an intelligent woman, and you're just amazing at what you do. So I have really appreciated everything you've done in my business, but I have just heard your praises from everyone else too. So if anyone's listening and they're looking to file, they should definitely get in contact with you.
I appreciate you. Thank you so much for even having me today. I enjoyed it. I truly did.
Yeah, thank you so much for being here. And thank you so much for listeners for listening to another episode of Spa Boss Talks. I will see you next time.
Thank you so much for joining me on another episode of Spa Boss Talks. I hope you found valuable insights that will launch your aesthetic business to new heights. Remember, your success is our mission. If you enjoyed today's episode, please remember to like, subscribe, and share our show. We want to help as many estheticians as we can become successful business owners. Plus, sharing our show is a great way to support our small business. Before we part ways, remember you're not just an esthetician, you're a spa boss in the making. Until next time, stay inspired, stay confident, and keep conquering the world of aesthetics. This is Nicole Lancaster signing off from Spa Boss Talks.